Actually, maybe I'll just click it and sit down. All right, we're going to go ahead and get 30 seconds in advance.
Steve is still making his way down, so we'll all watch him as he comes to this. No, I'm kidding, Steve. So let me get started. I'm Bruce Hoffman, the director of the Bureau of Competition at the FTC, as part of our unique FTC dual Bruce structure for the Bureau heads. We didn't find a Bruce for the Bureau of Consumer Protection, but I understand Bilal's working on that for the future. And thanks everybody for coming. We have a great panel. I'm going to introduce the panel in a moment. I don't plan to say anything substantive, and I'm standing here only because this is the only stuff I plan to say other than asking questions. I'll soon sit down and ask questions. But nevertheless, I'll give the disclaimer that anything I say doesn't necessarily represent the views of the Federal Trade Commission. And in fact, the purpose of these is to help us form views, so we really don't have views. We're trying to form them. Bruce Kobayashi introduced us or suggested that this being a panel of lawyers would be the unimportant panel or the less important panel. And I agree. I mean, the economists who came first, as you saw, spend their time creating elegant, sophisticated, and complex conceptual models with Greek letters, and we enforce laws and block mergers. So you can decide which is more important to you specifically, and pay the amount of attention to the panels that you choose based on that decision. But with that brief introduction, let me just say a little bit about what we're going to do that's different than the last panel. First of all, we have no slides, so we're not going to be flipping through slides. Secondly, being largely, with the possible, although debatable exception of Steve, a panel of lawyers and not economists, we're going to do more of a Q&A format, I think, based to a certain extent on the issues that came up in the last panel. So that's going to consist largely of questions going to the various panelists and getting their thoughts, and a somewhat freewheeling discussion about some of the issues raised by the concept of vertical merger guidelines, and also the issues that arise in vertical mergers and some of the thinking that's been going on about that. So with all that, let me just quickly introduce the panels. And I'll do well, you've already heard about Steve, so I'll skip right past Steve and go to Gene Kimmelman, who's the president and CEO of Public Knowledge. Gene served as the director of the Internet Freedom and Human Rights Project at the New America Foundation. He served as chief counsel for the DOJ's antitrust division, and he's held a number of other prominent positions in a number of categories, and is somebody that brings a great perspective to this. Sharis Posen is the vice president of global competition and antitrust at General Electric. She spent over 3 years at the antitrust division at DOJ as chief of staff and counsel and as acting assistant attorney general. She has worked in private practice in antitrust, and she's been at the Federal Trade Commission. So she's a dual agency recidivist, actually, in some respects. I make no moral judgments. Again, we're here to learn, right? John Salad is next. John is a partner at Steptoe. Previously, he was general counsel of the Federal Communications Commission and deputy assistant attorney general at the antitrust division. So this is a somewhat unusual collection of skills and background. John has also worked in the Department of Commerce, and he's a senior fellow at the Benton Foundation. And he also has spoken and given a very important speech on vertical mergers while he was at the Department of Justice, which I recommend to anybody who's thinking further about the subject. Laura Wilkinson is next. Laura is an antitrust partner at Weil Gotshal. Her practice focuses on mergers and acquisitions. She began her career at the Federal Trade Commission and served as Deputy Assistant Director for the Bureau of Competition's Litigation Division. And she is one of the most prominent antitrust merger practitioners out there, and no doubt will have a lot to say about how all these issues affect the day-to-day life of firms complying with the antitrust laws. And then finally, we have Paul Eady, who's a partner at Freshfields and the head of the U.S. antitrust practice of that firm. Paul has also worked at the Federal Trade Commission as counsel to 2 federal trade commissioners, as well as being an attorney in the Bureau of Competition, and is a longtime member and participant of the antitrust bar, as well as a prolific contributor to the intellectual debates that pervade the antitrust community. So it's a great panel. Hopefully we will keep you entertained and say something that's at least marginally almost as important as some of the things said in the prior panel. So thank you. And with that, I'm going to start asking questions, but from a seated position. This is on. So we just listened to the panel, the prior panel, about the economic framework in which you might assess the harmful or beneficial effects of vertical mergers and how that's done in the fairly sophisticated ways that economists do it. Laura, let me go to you first and ask, if you're looking outside of economic models, first of all, do you have a general sense, or is your experience that vertical mergers are harmful or not? And what evidence should we use or could be used from the more practical standpoint on a day-to-day basis to try to determine whether vertical mergers are harmful or beneficial?
Okay, well, I want to start out by saying thank you for inviting me to be a part of this panel. I appreciate the opportunity to add my voice to this conversation about vertical mergers. And at the outset, I also want to say that the views that I express today are my own and not those of my law firm or our clients. And so in answer to your question, I'd first say that look, most mergers are not harmful. Of the roughly 2,000 mergers that are filed under HSR every year, maybe 30 or 40 are challenged as harmful typically in a year. And of those, 1 or 2 are vertical mergers. And so we see so few vertical mergers are challenged and even fewer are litigated because they're less likely to result in anti-competitive harm, and they're more likely to result in cost-reducing efficiencies. So in my view, the standard sources of evidence used to evaluate horizontal mergers are useful also for analyzing vertical mergers. And these sources include, documents of the merging companies, whether they're documents relating to analyzing the merger or their ordinary course documents. We also would be able to look at the company's executives in terms of what they say, not only in their documents, but in testimony before the agency. And of course, we look to the views of industry participants, whether they are customers or competitors or industry experts. And of course, in the vertical context, some of these industry participants may be both customers and competitors of the merging parties. We also obviously look to data. Market shares are, of course, one of the important aspects, but there's lots of other data that's important in understanding the industry and the likelihood of harm. As we heard today, vertical market mergers in oligopolistic markets have more of a potential perhaps to raise anti-competitive issues. And so there it would be important to look at concentration levels at both levels of the upstream and downstream markets. Other evidence, of course, that we need to look at are whether there's entry and expansion possibilities by other firms in the market, whether there may be power buyers or other countervailing forces in the industry. And of course, we also need to understand the efficiencies. Vertical mergers are prone to have more efficiencies, as we've heard this morning, and cost savings are very likely in the elimination of double marginalization. However, we look at those in the horizontal context as well, but in the context of vertical mergers, they probably would be afforded a bit more weight, but I'm not sure that a presumption is necessary in terms of the analysis. The main difference in analyzing the vertical mergers is really the same as in horizontal mergers. It's a fact-specific analysis, and we just have to look separately at what the theories are in vertical mergers. Most typically raising rivals' costs, change competitive incentives, or information exchange. So what we're looking for is to determine whether there will be those types of harms versus the harm that you would see in horizontal mergers, but the evidence sources are really very much the same.
Great, thanks. So let me go to John and Sharis collectively and ask you a question that builds off that a little bit. It's kind of a two-part question. One is, when you were at the division and you were looking at potential vertical mergers, part A is, did you have the sense that there were a lot of vertical mergers that you were concerned about that you thought might be harmful, but there were inadequate tools with which you could bring a challenge to those mergers, whether the tools were the lack of coherent economic theory or whether they were legal decisions? In other words, was there a high risk of what Bruce described as type 2 error, where you thought there were a lot of potentially bad deals but you couldn't do anything about? Or was it the case that you just didn't see a lot of potentially problematic vertical mergers And what were the facts, what were the kinds of evidence that were most important to your assessment of them?
You want to go in order of service? Do you want to go first?
Either way. You know, I share Laura's thanks, and I really want to commend the Federal Trade Commission for these hearings. I think it's important to have a discussion on all the topics you're covering. These topics in particular today, I think, are important, and I am privileged to be a part of it, so thank you. And in terms of what we saw when we were there, I will say it seems like every vertical merger that came in, I was recused.
Well, that's convenient.
Yeah, that was convenient. Yeah, except for maybe Ticketmaster Live Nation. When we first walked in the door, you know, that was a horizontal merger in ticket sales with verticality in terms of venues. Google ITA is one that where there was a consent agreement, and NBCU Comcast. You know, and so I can't talk about the specifics. Gene was there with me, and so he can talk about the specifics. But in terms of the tools in the toolkit, you know, how you can address the issues, I think we all agree. I think that the vast majority of vertical mergers have tremendous efficiencies and synergies, and make sense from a pragmatic standpoint of why these two companies want to join together, what the efficiency gains will be, what the innovations can be. You know, using Carl's example of the microprocessor and the computer together, and how that interface can be worked. In terms of the tools at the time, you know, remember when we were there, we revised the merger remedies guides, right? And we did that in large part, you know, wanting to convey not only that, you know, there is a presumption that you do want structural remedies in all cases when you can get them, but there were times when you should consider whether there were other alternatives available that might solve the problems. And there's a part of me that thinks because of some of the actions we took in those cases, that's why we're here today discussing it. Because I think, you know, folks look at those, and there are those on, you know, certain sides of the spectrum who say, oh my God, they were so behavioral. And yet, you know, I would question, you know, in the recent litigation in AT&T Time Warner, you know, I don't think there was any evidence that there was any issue in administrability with respect to the consent agreement and NBCU Comcast. And so how bad was it? Is it just a philosophical issue that people were concerned about? So I think there are tools in the toolkit. I think when we were there, we used them when we thought it was appropriate. There might have been, you know, a level of experimentation sounds, you know, maybe a bit extreme, but there were times when we tried to get it right, where we wanted to allow the merger to go forward, to allow those synergy gains and efficiency gains, but where we thought we could control for what we thought were going to be the anti-competitive effects, and tried to do it very carefully.
John, did you want to add to that?
Yes, if I could just briefly. So I think I was there at the end of the Obama administration. I think we were coming to the view, and Bruce, you were kind enough to refer to the speech I gave. I gave the speech actually because we thought, this was Renata Hesse's decision, that we ought to sum up what we thought we had learned over the previous years, for whatever future use it might be. I think we thought a few things. One is, one ought to note that when consent decrees are entered into, it's because the division believes there is a valid theory of harm, that it is willing to say is a valid theory of harm leading to potential harm on the record in court, albeit non-litigated, but a very definitive position that there was harm that would have come, absent the consent decrees at least, from a series of vertical mergers. Sheriff mentioned them. Live Nation Ticketmaster, there was a UTC merger, Comcast NBC. So we felt as though we actually were building a body of precedent about what kind of harm might exist: input foreclosure, customer foreclosure, use of sensitive information flowing around from a vertical partner to rivals, potential competition, one into the other's market, on which we could rely. We thought we knew that. I think we did think that it would always be useful if economics had given us something like the model we have in horizontal mergers of HHI as a starting point, not an end point, but something akin, is there something akin to the structural presumption? And we heard a lot about that on the panel earlier. In terms of litigation, I think we thought that let's take Upstream, input foreclosure. If one had an input, and it would be advantageous to the new company to deprive it of the rival, and the rival needed it a great deal, and the deprivation would cause competitive harm, then one could prospectively litigate, although we didn't, one could prospectively litigate that on the facts, even without all of the economic modeling that might sometimes be preferred. And we had circumstances where we thought hard about such challenges. In a couple of cases, as people recall, mergers were abandoned before processes were finished. So I think we felt that we were making a good start. The last point I think we thought about, and Bruce, you mentioned this in your speech on vertical, is are those circumstances in which behavioral remedies might not be workable. And so I felt like we thought we had a good handle on how to proceed, but there was a lot more work to be done, which I think brings us to the question of new guidelines.
Thanks. Let me go quickly to Paul. Paul, to follow up on that, did you have a sense, or do you have a sense that there's a large set of vertical mergers that the agencies would like to challenge but aren't?
I don't, but at the same time, I think actually vertical merger guidelines could facilitate maybe challenging a few more. I just want to say a few things, I guess, maybe just on the point of guidelines. And by the way, just I think a lot of what I would say, and I have said, and I said in an article about 10 years ago, really hasn't changed, and it's largely was restated in Professor Lafontaine's slides and in some of what she said, that vertical mergers actually might be anti-competitive. The issue today is whether we can actually create useful guidelines. That can we state guidance that allows us to distinguish pro-competitive from anti-competitive mergers based on generalized and observable criteria. And more about that in just a minute, but I wanted to just knock down one of the straw men that keeps getting set up, which is the 1984 guidelines. I think I've said in the past that we didn't really need to revise the 84 guidelines. Mostly I was saying I just didn't think we needed to do anything about it. But I'm happy to just knock down the straw man and say that nobody pays any attention to the 84 guidelines anymore, just as Carl, as you said. I think I haven't looked at, even though I've done a number of vertical, and by the way, vertical and complementary we'll treat as essentially the same, vertical and complementary transactions over the last many years. I don't think I've looked at the vertical merger guidelines, the 1984 guidelines, in at least 10 years, and probably I did it then only because somebody asked me to. I didn't even look at them for purposes of preparing for this panel, and I'm not sure how many people did. Okay, one. All right. So let's just ignore that, and so whenever we get into the debate about whether we should revise the vertical merger guidelines, let's actually just pose it the way we should pose it, which is, should we create vertical merger guidelines, and just assume that right now there really aren't any because nobody's looking at 1984. And then so back to the point about guidance and theory. There is a fundamental difference, as Francine said. There's a fundamental difference between substitutes and complements. I think we all learned that in our first micro class or maybe in high school. And I really enjoyed, by the way, Dan O'Brien's wry comment that a lot of the analysis is the same, but the coefficients have different signs. I mean, that's a really kind of simple way of putting that there really is a fundamental difference between substitutes and complements. So thanks for that. I'll remember that in the future. But there is we've got a basic difference in theory. There is a basic difference for all the reasons that have been described previously, and I won't try to restate those. But there is a basic difference in theory that suggests that we should be treating horizontal and vertical guideline or vertical mergers differently. Just by the way, Steve said, and I don't want to provoke Steve because then he'll take up all the response time. But Steve said in commenting on my article, in his article, in the Yale Law Journal article, that I only focused on the two polar cases, and he described that as essentially what the primary critique is based on the two polar cases, the perfect competition, both levels of perfect competition, both levels at monopoly. That was essentially 2 paragraphs in the entire article, and the rest of the article I spent on the post-Chicago theoretical literature. Basically, it's that literature that we've been saying, and I think that we heard from Dan O'Brien and from Francine and from others, including, to some extent from Carl, that that suggests uncertainty and ambiguity with respect to the possibility of anticompetitive effects in vertical mergers, but also suggests the high probability of efficiency and pro-competitive effects from vertical mergers. So again, I don't want to revisit all that, but it has been discussed at length already. And by the way, just back to the original point, about whether lawyers, have all that much to say about this. With all due respect to the panel and to my own role as a lawyer, I'm not sure that we actually do with respect to whether there should be guidelines or not. But back to the theory. There is a lot of ambiguity. There is ambiguity, basic theoretical ambiguity in the economic theory of anticompetitive effects for vertical mergers. I told you I was just going to say what I was going to say, regardless of your question.
I was forewarned.
And that so that we think that there should be empirical evidence. And this has been said again many times, not just by Slade and LaFontaine and others, but for years, that where we have this ambiguity. Salinger said it in his original paper when Jeffrey Church did that massive analysis of non-horizontal merger theories for purposes of justifying the European Commission guidelines. He said the same thing, that there basically is not a sufficient basis in the theory for vertical merger guidelines, for any non-horizontal merger guidelines. And so we really should try to see if we can get some more empirical evidence. And I think this was touched on just briefly, but I think not long enough in the previous panel about why we haven't done and developed more empirical evidence of anticompetitive vertical mergers, when I think everybody would agree that there's been this long period of time where we had essentially a laissez-faire approach to vertical merger enforcement. So we must know, and I think that's fundamentally the basis for your reinvigorating vertical merger enforcement paper, Steve, and I think to the statements that have been made previously about the lack of vertical merger enforcement. We must have a vast number of deals out there that during that period you would consider to be anti-competitive. I know you mentioned some of them, but we should be studying those, doing a retrospective to see if in fact we can develop a more robust support for some kind of a vertical merger theory that then would support or at least answer the questions of ambiguity that were raised by Dan O'Brien and have been raised by economists forever about vertical merger policy.
So me using up all the response time?
Yeah, I am.
Right, so we're debating whether to give you a specific rebuttal piece at the end or to fit it in.
Yeah, the only other thing I'd say, just because there is so little time, is to just suggest that I think there's a number of comments, a number of papers that people should read on this, because we're not going to be able to cover them all, and even the economists couldn't cover them all in their session. But certainly with respect to the empirical literature, LaFontaine and Slade, and the other articles have been written. Dan O'Brien has contributed to a number of these, but more recently, just the GMU paper that attempted to kind of summarize the more recent empirical literature in the area, I think is helpful and important.
Yeah, and a lot of those papers are collected, including some of the responses to those papers are collected in various places where if you look up vertical mergers, you can find cross-references to all those papers. But let me go to Gene quickly on this. So Gene, right, from the standpoint of both having been an enforcer, but also from now working at an entity which has a public standpoint on this, which is more of an advocacy and knowledge group. What's your perspective on the state of vertical merger enforcement? Are the agencies missing a lot? Is there something that that we're just blind to, or that we've been unable to do anything about in terms of a significant number of vertical mergers that you think are problematic that ought to at least be getting remedies, if not outright prohibitions?
So I think that I need to step back even before that, because starting 30 years ago, I was probably audacious enough to challenge conventional wisdom of everything Paul just said. And I was banging my head, challenging mergers and asking enforcers to challenge mergers and challenge what I thought was anti-competitive behavior in vertically integrated companies. So back to Time Warner Turner and in that era. I think what's being missed here is actually one of the things that is most important about what you have done with these hearings, which I applaud the FTC for doing, which is you've opened the kimono here on antitrust. And it isn't just about economics, and it isn't just about lawyers. It's about the society, and it's great what you've done. And I will urge you to continue it. And when we were at DOJ, we did field hearings on agriculture, and I urge you to go into the field as well, because the public cares about this. And the things that I was fighting about starting 30 years ago is a public sense that there are greater harms in vertical integration. So has there been enough enforcement or not? You know, we can go back and look at specific cases. I don't think there's a magic number, but I do think there is, it is a time here where we need some guidance. You know, whether it's actual guidelines or it's something comparable, I don't know. But Judge Leon referenced the 84 guidelines in the AT&T case, so it's not insignificant whether Paul wants to look at it or not. If jurists are using them, then we've got a problem. So we need to update. I think Steve is right on target in focusing on oligopoly markets. And again, I want to put it more broadly. We remedied the problems of vertical harm by passing laws. Congress in 1992 passed the Cable Act because of the dangers of vertical integration blocking the development of competition. It didn't wait for the antitrust laws to ponder and question and whatnot. It felt it was fairly obvious. So there are situations that clearly require intervention, and I think we need to be very mindful of it. So I appreciate the focus. I want to say I think that it's very important to look beyond the simple economics. John Sallett references it. These are key fact patterns. Can you say something generalizable? It may not be anything near the kind of pros in the horizontal merger guidelines, but it would be extremely helpful, and to open it to the public, to have a discussion of what are the efficiencies, how do they arise, what can be handled through contract. I think Carl framed it extremely well, and I came away from that thinking that where you have key questions, probably the biggest issue for the enforcers to focus on is who bears the burden. Because I think the problem in enforcement has been too big a burden on the government and too little on the defendant explaining how contracts wouldn't suffice, or there are alternative ways to get efficiencies. And so I think I think enforcement has been tempered substantially because of a concern of the burden on the government, number one. And number two, I think a concern about litigating the fix. So I think that the problem is not just going into a court with a judge who may not be expert in antitrust, but a judge who sees some kind of a behavioral remedy put forward and has a much greater difficulty discerning whether it remains substantial harm that needs addressing, as opposed to what a defendant has offered up. So I think that's actually the biggest problem that remains for enforcement. So I would urge you to go forward with some kind of guidance and really opening it up to the public, so there's at least a broader understanding of what antitrust enforcers are grappling with.
Thanks. I'm going to come back to remedies because I think there's a lot of stuff to talk about there. But I wanted just one last point in this to follow up with a question of Paul, which actually builds on something you said, Gene, which is obviously Judge Leon cited the 84 guidelines. I know that a lot of us inside the community have said nobody pays any attention to that. But Paul, isn't that very much an inside the Beltway kind of situation? I mean, and not even just inside the Beltway. I mean, if you're on Capitol Hill, if you're in the antitrust subcommittees, or even on the Hill more generally, and you're looking at what's the state of the law on vertical mergers, isn't it the first thing you're going to look at? And then even beyond that, what about foreign enforcers, people developing vertical concepts for enforcement overseas? You know, if they're looking at the historical development of analysis here, aren't the 84 guidelines, so it was Halloween yesterday, so aren't they sort of still rattling the chains like the ghost of Marley out there?
So I think that's a good point, and I agree. So I think we should withdraw the 1984 guidelines so that they're not confusing. And I'm quite serious.
Leave nothing in the place.
I'm quite serious about this, because then the question is, what do you do next, right? And what do we have, on what basis would we actually draft guidelines that for non-horizontal mergers generally, right? You can look at the European Commission's non-horizontal merger guidelines, and maybe that's the direction we go. There's a lot of problems with the non-horizontal merger guidelines at the European Commission. But, you know, the question really is, and I really do agree with the point that there are going to be people who, when they want to know what the agency's policies are, they will look for those 84 guidelines. I get that. We don't, generally, right? But in terms of what you do next, what do you do next? right? I mean, and the, you know, do you do this kind of burden shifting? You know, that we've heard this from Steve, the burden shifting in a case in horizontal mergers, it makes sense, right? For the reasons that Carl explained, the difference between horizontal and vertical mergers. But in the vertical merger context, where in fact there is an inherent efficiency, there's an inherent pricing efficiency. The question is, how substantial is that pricing efficiency that's achieved, and is it outweighed by the potential anticompetitive effects? But in this context, we're talking about the possibility of shifting burdens onto parties to explain why the transaction is not or is efficient, or how they've kind of the merger might be the least restrictive means of achieving those efficiencies, which is kind of a pretty tough burden for them to establish. So, I mean, I think it is an inside the beltway point that about the 84 guidelines, but I think in terms of what we do next, we really have to think carefully about what the economics tells us about the right standards and about where we establish burdens on the parties.
Thanks. So, Sharis, you wanted to add something to this? And then I'm going to go to
Yeah.
Steve, because otherwise he's going to grab the mic. And
Well, listen, as I said, I think these hearings force us all to sit down, think carefully, think thoughtfully about the issues that have been raised this morning in the economics and otherwise. And I have to say, as folks know, Carl Shapiro's hard to disagree with, right? And so, and the point about the judge using those guidelines is hard to disagree with, right? And so we have a set of guidelines that the whole world knows we have out there, that Europe has its own set of guidelines that are more recent. So to answer your question, Paul, what do you do? The thing I feel like just listening to the last panel and then listening to this panel is we're struggling with the model of a guidelines, right? That a guidelines that I know from my, the horizontal guidelines as they've evolved all talk about, what are the effects, what are the markets, how do you define them, what's a SNP test? They're robust and encompass all aspects of horizontal mergers, right? So could you actually come up with a guideline that, encompasses all aspects of vertical mergers in that similar fashion? And I think that's where the answer is coming as no, you can't, right? You could, but I think it would be very, very difficult to do. So isn't there something the agencies could do that's different from that? Isn't there a policy statement that the agencies could make, about vertical mergers and how they're approaching them, about remedies and how they're approaching them, to go to Carl's point about, answering the question about remedies? And that would not be a guidelines, because that's just, Paul on our previous call said this is a solution in search of a problem. That's, one point of view. I think this is putting a square peg in a round hole of guidelines.
So I know, John, you want to say something, and I actually have a question for Steve and then for you, and then I have a follow-up question for Laura on this issue. But turning to this question about construction of guidelines. So, Steve, I think you've articulated what could be a framework for a fairly complex and robust set of guidelines, a la the horizontal merger guidelines. Or you talked during your presentation about something that would be more prose and less rigorous analytical content, like and you have it open in your slide deck, the proposed conclusions of law from ATT. And then, John, I know you've looked at the development of precedent, the development of the 84 guidelines, but also the development of the horizontal merger guidelines did not start out with anything like the thoroughly articulated framework we have today. So I'd like, if both of you wouldn't mind, I'll start with you, Steve, talking about what actually would be needed in guidelines and how robust and analytical and thorough do they need to be useful relative to the world in which we don't have them, where we have the 84 guidelines.
Okay, well, first of all, I don't think it's so hard. Dan, Colley, and I have a draft. You could start with the draft and see what, we set out what the analytics were, we set out what the evidence would be, and we set out the set of policy questions that the agencies would need to resolve. And we did it in a fairly balanced way, best I can do in terms of balance. So I don't think it would be that hard. But if you wanted to be lazier and do less, you need to take...
That's in a non-pejorative, non-judgmental sense.
Exactly. Let's talk about whether there's consensus on any of the issues that you raised.
We need the guidelines because the agencies need to state their enforcement intentions. Okay? If what we have right now is AT&T Time Warner's proposed conclusions of law, and we have your speech from last year, well, that's the whole breadth.
It was John's speech, too.
And John's speech. That's a pretty, what's a businessman going to read to figure out whether you can allow the merger. That's all over the place. So we have this whole controversy this morning about who should bear the burden on EDM and other efficiencies. At the very least, the agencies need to take a position on that. Okay, now, of course, Paul and I disagree. Now, maybe it's because he only had one course in economics. I don't know. But across all of antitrust, everywhere, the defendants have the burden to prove restraint-specific efficiencies. That's true in Section 1, that's true in Section 2, and it's true in mergers. I don't see why vertical mergers should be different. And, I guess that's the question I want to put to Paul.
So, John, you wanted to add something to this?
I do, just because I think, look, there's a simple answer to all this. It's all Carl Shapiro's fault. He did such a fabulous job writing the 2010 horizontal merger guidelines that people are taking the view that if we can't be that great right away, we should do nothing. And so, what can I say? I reject.
This is the Carl
premise.
Shapiro Memorial
Correct.
panel.
Yeah.
This is,
I actually wouldn't even go that far, John.
But I will say I reject the concept, right? I love the horizontal merger guidelines, but of course work proceeds. Of course we know better. The 1968 horizontal merger guidelines are not the same as their subsequent versions, including 2010. So the question is there a purpose for vertical merger guidelines? Are there topics that we believe can be discussed? I think the answers to both are yes. First, it's very useful for the bar, for businesses, to understand how agencies will proceed in investigating vertical mergers, and as somebody said on an earlier panel, whether the two agencies have the same view. That's fundamentally important. So then what can we say? Look, I think there's a number of things that we know we can say, and that's even without having to steal everything from Steve's articles. We can identify theories of harm. What theories of harm will an agency investigate? Input foreclosure, customer foreclosure, potential competition, information flow. We know we can establish those, I believe. Secondly, what kind of efficiencies will be looked at and how will they be examined, right? We know double marginalization exists, but as in Comcast NBCU, it was found it wasn't merger specific. That was an inquiry that the agency undertook, and we can specify what we would likely want to look at. We can talk about remedies, which in your vertical speech, you talked specifically about, Bruce. It's a very important issue. The Justice Department may have a different view on this. Also an important point for possible reconciliation. And then finally, I think, well, no, two more. One is one can ask the economists, are there any presumptions, right? Maybe there are no presumptions. But of course, as Steve has said, the lack of a presumption doesn't mean the inherent failure to be able to make out a prima facie case. It's just we want to know, are there such things that can be implemented? If there are, great. If there aren't yet, don't include them and continue the research. And then finally, I do think it seems very common sense that the Baker-Hughes methodology used for horizontal mergers of a prima facie case, rebuttal, balancing, if you get to the third stage, makes sense in the vertical context, and I think it would be useful for the agencies to say that. So, of course, I'm not suggesting that horizontal merger guidelines shouldn't try to go further than I have just outlined, but it does seem to me there's more than enough here and more than enough need to justify the two agencies working together to promulgate them.
Thanks.
So I'll go ahead and answer that.
Go ahead, Paul.
Yeah. So I think, leave it to Steve to go ad hominem when he's losing an argument. But,
So we're gonna try to refrain from the. I mean, that's good for academic debate. I understand that's how it works in the university, but we'll.
But I think what John just said is consistent with what Sheriff said, right? Which is we're not talking about guidelines. We're talking about.
No, I am talking about guidelines, Paul.
No, I know, but I'm saying I was saying it's consistent with what Sheriff said, which is that we actually you're describing. Stating a set of issues that need to be analyzed, as opposed to actually describing essentially a set of observable conditions that imply that there is some underlying model that we're following for this. I mean, I think if you want to just say, and the two agencies can say, we think about vertical mergers in the way that Bruce Hoffman described in his speech, I think that's great. I think if you want to say, as Macon Delrahim has said, we think about behavioral remedies in the context of vertical mergers in the following way. I think that's fine, although I think he was wrong on that. But I think that's different from actually stating guidelines of the type that were drafted in 92 and in 2010.
Okay, so I want to go to, let me go to Laura, and then I have a question for Gene. But actually, before that, I was reminded that I need to underscore to the audience that you have the opportunity to send us questions on note cards. I will ask them, and in fact, the question I have for Gene is a question I was sent to ask him, but I'm going to go to Laura first. But please feel free to send up questions, and they will get asked. Laura, I know you wanted to say something, but I also want to add a question to you, which is, in light of all this discussion we've had, as a practical matter, one of the issues that's come up is, as a practical matter, what do business people do, right? How do they make decisions? And my question for you is, without waiving attorney-client privilege, what do you tell them? How do people actually navigate this land right now?
Well, that's a great question, and that's exactly why I think that either whether you call it updating the guidelines, coming out with new guidelines, or calling it something short of guidelines, but to provide some guidance, not only for the agency staff, but for us as the antitrust bar, for the business community, for the courts, for the public. I think that while it's true that they will have to be somewhat complex, but I don't think that that's a sufficient rationale for not doing something. I'm reminded of the adage, don't let perfect be the enemy of good. Just because we can't clearly articulate every single economic model, I think there's some basic things that we understand about the types of anti-competitive harm that we look at in the vertical merger context. Even in the old 84 guidelines that we're disparaging today, it does reflect several different theories of harm, and so we would do the same here. I would expect you'd outline the several different theories of harm. And you would obviously talk about the pro-competitive efficiencies that vertical mergers may exhibit, but also talk about the instances where that may not necessarily be true. And in terms of counseling, because there are no viable guidelines right now, we have to look to what the agencies have done in terms of prior enforcement, and to the extent that they have issued press releases or speeches that provide a little bit more background on why they made those decisions, that's really what we're left at looking at, and speeches, as we've talked about today, including yours. However, I think that we also look at, in terms of counseling, we look at the economic literature, because we know that those are the things that the agencies are looking at, or we assume those are the things that the agencies are looking at, and we want to make sure we can run our facts by those theories and see what the agency might do as part of their review of the transaction, so that we can be prepared to have arguments in response, or also just to counsel clients whether to go ahead with the transaction or not. I think that the guidelines will also help in terms of counseling, because there has been uneven enforcement between the two agencies, but among different groups within each of the agencies. Also, because of that, it's difficult to necessarily have one answer for clients, but to give them a range of, this is what may or may not happen.
Clients always love hearing that, too.
Exactly, and so that's again coming back to why I think guidance would be very helpful in terms of being able to point to the current views of the agencies, and as someone pointed out on the panel earlier, to show whether there are differences between how the agencies are looking at vertical mergers today, as well as the possible remedies, which I think is a point we're going to get to on this panel, but an important point in terms of counseling clients. This is not only how they will analyze it, but is it likely that remedies would be needed, and if so, what might they be?
Great. So, Gene, you wanted to say something, but I also want to ask you the question that I got from the audience, which was that you had mentioned public concerns about vertical mergers that relate to non-economic issues, and the question is, what are those non-economic issues? And I would add to that, and what kind of suggestions would you have for how we would address non-economic issues, either in enforcement or in guidelines in the vertical merger context?
Yeah, so the point I was just going to make is that if we've all convinced you to rescind the 84 guidelines and replace them with something, we will have accomplished something here. And we can debate exactly what needs to be in that. So what I was referring to was not purely non-economic, but not using the precise econometric tools or the precise tools of antitrust economics as the sole basis on which to think about problems of verticality. I think a lot of what the public responds to and is very frustrating in antitrust enforcement is that we often have markets that have become more concentrated either because there was a lack of regulatory intervention in some sectors that maybe should have happened, or previous mergers that have led to higher levels of concentration. And then when you look at a specific merger, the public expectation is you're solving for everything, which is not what you are doing in antitrust enforcement. And I think there's a huge disconnect between what the public expects in antitrust enforcement, just using that kind of an example, and what you can actually deliver. So a lot of it is economic. A lot of it has to do with harm to innovation, harm to potential competition. It deals with maybe even past mistakes. But it comes out in an entire framing on, if you do not block this merger, you have not done your job. And I think it's a conflation of a broad set of factors that the public has these broader expectations that I think we need to be thinking about, but not necessarily by fundamentally changing antitrust enforcement approaches, but by thinking about what deserves sector-specific attention, what possibly deserves sector-specific regulation or oversight, as opposed to antitrust. In the communications sector, there is a statute that promotes localism, promotes diversity of viewpoints, promotes diversity of sources of information in electronic media. Those are not things that we commonly talk about as we're looking at a particular merger for antitrust review on its face. They may be side effects. So there are a lot of other factors here that they're economic, but they're not the same kind of quantitative measurements that we're doing in antitrust enforcement. And I think it's really important not just to identify those, but for the agencies to think about taking a position. They do competition advocacy, we all have been there, about what else the government should do that isn't antitrust, but that is pertinent. I go back to the Cable Act. I mean, that was a direct intervention that one arguably could have done through antitrust. I don't think it would have been successful at that time. Congress jumped in, and it went far further with banning exclusive arrangements, limiting vertical integration and horizontal concentration for a specific industry in a specific moment in time. So I think those are some of the things we need to grapple with around antitrust as we discuss what we're doing, both with guidelines and enforcement, to help both the public and broader set of policymakers think about what other tools they need to bring to bear.
So let me just ask a quick follow-up on that. So is your point that antitrust ought to address these issues, or that the agencies have maybe had a communications failure in inadequately explaining to the public at large that for those kinds of issues, we don't include them in antitrust, and there are good reasons for that? And I'll tell you, having recently had an hour and a half and more glasses of wine than I care to admit argument with my father over why we're not completely failing to do our jobs because we don't protect small business and watch out for fairness. I do understand the public messaging failure, at least with regard to him as the audience of one.
That audience of one is probably very reflective of the entire public. I'm not trying to, I do not want to force a broader set of issues into antitrust analysis. I want antitrust to push the envelope on what it is capable of doing. And I don't think we've done as good a job in vertical enforcement, in looking at potential competition, and in fully assessing innovation and quality. I think we can do more, but a lot of what the public is expecting is not antitrust. I think we have done a terrible job communicating that to the public, and I think these hearings can be a piece of starting that process better, but it shouldn't be, sorry guys, there's no solution. If there's a real problem that people care about, if they're worried about too big to fail, if they're worried about problems in agriculture that are discrimination but not antitrust violations, we ought to be thinking about other tools to address those. And I think that's where the competition advocacy function of the enforcement agencies should come to bear.
Okay, so I have two questions from the audience that I'm going to ask, and then I want to go to remedies to make sure we cover that before running out of time. The first question from the audience is an interesting one, and I think I'll throw it, I guess, originally to Sheriff, but really open it to anybody who wants to answer, which is, should incipiency be a ground for greater scrutiny of vertical mergers, and if so, when? So I guess the idea is that fundamentally, if we're talking about Clayton 7, we're talking about an incipiency statute, and it's always predictive, except in the case when we have a consummated merger, obviously, and even then the analysis is predictive. Since we're talking about prediction in vertical mergers, should we be more skeptical or more careful in prohibiting or seeking remedies in those contexts, given the statute?
Yeah, I can't see why. Honestly, I can't see why. Maybe Steve will tell me why I'm wrong there, but I can't see why you'd have more. I think it's actually quite the opposite, right? I think we know that vertical mergers generate synergies and efficiencies. Steve gave the example of McCaw AT&T. That's probably the one merger that we could come up with. Maybe there's a couple more, but the vast majorities have tremendous synergies. So I would say absolutely not. And I think the reason why is, again, we know what can be produced through verticality. We know the abilities and innovation that can, as long as competition is continuing at both levels of the equation in a vertical merger, right? And so that's kind of the answer. And I want to go back, though. I can't help myself but go back. I just want to make clear, I'm not advocating for guidelines. I am not advocating for guidelines. I don't think we have a consensus on everything that you have right there in the government's position in AT&T Time Warner at all. And so I really don't think you could come up with guidelines where you could find a consensus. I'm advocating for something less than that.
Yeah, but that's why you have to go through the process. If you fail, you
Exactly.
fail.
That's right.
But that's what it's all, there's a lot of controversy over the 2010 guidelines.
I know.
Including by the chairman of the FTC, right?
Right.
I mean, so it's the process that you need to go through. And to say we don't want to go through, we're not going to go through the process because we're not sure of the answer. The agencies need to tell merging firms how they're going to view, whether efficiencies are merger specific or not.
Right.
And you need to tell people how to analyze them. Because right now, we all know, sheriffs, right now, the guidelines are my article, okay, the analytic guidelines. Well,
I had thought
that's
they were
what happened when
Bruce's
you
speech
hired me.
and your article.
I don't know that, again, that's my point on consensus. I don't think we've reached a consensus on those issues at all. And so your point is we're going to reach a consensus by going through this process, I think is false. I don't think that's possible.
There's
I
two
don't think
things the
that's
guidelines
Steve, let me-
do.
let me-
No,
let me-
there's two things the guidelines do.
We're gonna degenerate into free-for-all,
One is
but I'll let this go, and then
lay
we'll-
out the analytic framework, and the other is they make policy cuts. And what you need to do, what the agencies need to do, is make the policy cuts.
Can I just have 10 seconds? I just want to agree with Steve. It's very difficult to copy edit a blank piece of paper. The first thing you do is you write the sentence, then you see does the sentence work and does the next sentence do work. There's enough need for vertical merger guidelines that I think one ought to try to write the page. If it doesn't work, it doesn't work.
Well, let me ask this question. So, Paul, you have been, I think, and have written on this subject, one of the more outspoken opponents of the idea of vertical merger guidelines. Do you object to a process of trying to write them to see if something comes of it?
Yes, sort of, because I'm sort of contemplating who would be involved in that process. But I think if you could actually come
Fortunately,
up-
I'm used to being insulted. It happens literally
No, if you
every
could,
day.
no, I think actually what John just mentioned, a page. I'm good with a page, right? A page that says, we're only going to look at vertical transactions where, we're confident that we're looking at an oligopoly at both stages. I think that's a good set of guidelines, and that's a ramp basically off of doing anything more. I think anything that you do more leads to the possibility of setting standards that as I've said before, and I'm not going to repeat all this now. People can go read my article, and I'll circulate it to everybody in the audience as well. But what are described as necessary conditions, and that's the best you can do with respect to vertical merger guidelines and non-horizontal merger guidelines, become sufficient conditions, and that's just a natural consequence of the way these things work. It happened, with respect to guppies, where the original authors basically described that as an on-ramp into the analysis that also was supposed to take into account efficiencies, some kind of a standard efficiency associated with the guppy calculation, and instead it sort of became what was considered a sufficient condition in a number of cases at the FTC and the DOJ. So, and that's certainly the way that we saw it when we were on the other side of the table from the economists who were working with guppies. So, look, and I think that's faded over time. That's good, that it's actually become a more rational analysis, and maybe that's what happens with vertical merger guidelines. But there's certainly a much more, more sound theoretical basis for the horizontal guppies than there is for whatever we would try to do with respect to vertical merger guidelines.
All right, so I have another question from the audience, which I'm going to ask before going to remedies. But I should preface this question by saying whoever wrote it apparently forgot that this was the lawyer panel, and not, with the exception of Steve, not the economist panel. So the question is, Steve, no, more generally, how can we treat EDM as a tack-on efficiency when the effect is isomorphic with the price increase from a horizontal merger? And to rephrase that slightly, I think the point, to put it in lawyer English, I think the point is that EDM, unlike a lot of horizontal merger efficiencies, and Carl touched on this, is an inherent effect of internalizing externalities, just as the price increase implied in a horizontal merger is an effect of internalizing externalities that competing firms impose on each other. Right. So it's really, it may or may not actually exist in particular circumstances, and the magnitude may vary, but it is inherent in the process of a merger of complements. So why should we treat it the same way that we treat efficiencies, which are not structurally inherent, or at least implied by the same mechanism that would give rise to the anti-competitive harm?
Let me just ask the same question I asked before. Why couldn't AT&T and Time Warner have solved the double marginalization problem without the merger? The DOJ failed to ask that question until they wrote their proposed conclusions of law. Okay? So I think in fact the way the DOJ might see it is that Carl just put EDM into his model because he put it into his model in case it turned out to be merger specific. Carl never took a position on whether it was merger specific. AT&T never explained why it was merger specific. Therefore, it follows that if the DC Circuit says the burden on merger specificity is on the firms, then AT&T fails. And the merger's found to be anti-competitive.
So go ahead.
So that's all I'm saying is why couldn't they, I just want to put to the merging firms, as I always put to my clients, why couldn't you have solved this problem without the merger? And they often come up with a good answer, but sometimes they don't.
Okay. There's a subtext in there that I might come back to in terms of merger specificity versus the isomorphic question, but we'll leave that for now because I do want to go to remedies, and I think almost literally everybody on the panel wanted to talk about remedies. So obviously the predicate here is there has been a lot of talk about remedies, and most prominently, as I'm sure everybody here knows, Assistant Attorney General Del Rahim has said on a number of occasions that the DOJ is extremely skeptical of behavioral remedies in vertical mergers. And as John pointed out, the FTC has said on a number of occasions, myself and others, that we are also skeptical of behavioral remedies, but we also have used them and they have worked, at least as far as we can tell. And so that in cases where the efficiency of a vertical merger is real and cannot be achieved without allowing the merger to go through, and where we think a behavioral remedy actually could work, we have done that, and we've not ruled them out. So that's sort of, I think, the state of play on this. I could be wrong about that, but let me go. I know Sharis and Laura wanted to talk about this specifically, Jean as well. Let me just go in no particular order to Sharis to comment on this issue.
Sure. So I think, again, going back to Steve, I think that's where the uncertainty comes in, right? It is in the, I will say, up until the challenge of AT&T Time Warner, I think I felt fairly grounded in advising my businesses on vertical mergers. And then with that challenge and the DOJ's positioning of that case, to be quite honest, and even in their findings of fact, I felt ill at ease. And I also felt ill at ease with the combination of the very strong statement at the fall forum that you mentioned, Bruce, that the AAG made about remedies in this circumstance. And there is, I want to give credit where credit is due. If you read the speech carefully that the AAG gave, he did preserve some instances where he thought that remedies would be acceptable, although we haven't seen that defined by the DOJ. I know the FTC has accepted, in the Trump administration, has accepted a remedy in a vertical merger in a context very specified, in which there was a statement around that specificity because it was the defense industry, right? So yeah, we're watching it. When I sit there at General Electric Company, we're watching it and watching it carefully so that we can give good advice. To Laura's point about advising on that, again, I felt comfortable up until that point. We'll see what the court does. To your point, Steve, we'll see what the Court of Appeals does, and maybe we'll have even more guidance. But I want to take a step back, and this notion in terms of remedies and behavioral remedies, there is a spectrum of behavioral remedies, and we seem to lump everything in together into one category of behavioral. It's a very broad category. We see remedies that can include, reinforcement of contracting provisions that exist, licensing remedies, all the way up to the arbitration baseball remedy that we saw in NBCU Comcast. So that's a spectrum. And I am concerned, not that we would do anything that would require a remedy at General Electric Company, but if there were a circumstance where it could be easily resolved in a remedy quickly without compliance with a second request, without going through all of the efforts, because the staff has a binary choice right now of sue, no sue, right? So they have to do an extraordinary thing in terms of investigating. If there was a way to come forward with a remedy that was administrable, that wasn't overly burdensome, that wasn't overly regulatory, which I think one half of the pool of behavioral remedies is, then why wouldn't we think that would be okay? Why wouldn't we go forward and allow a merger to proceed? It has efficiencies that are proven, that doesn't have foreclosure, where the parties don't have the incentive and ability to foreclose, but there's some concern out there by competitors or others. Why wouldn't we do that? And I don't know that I've had that question answered at this point. I'm hoping through further development as we watch the agencies that we'll see that. But I think, to me, that's the uncertainty I feel. I don't feel uncertainty because I don't have vertical guidelines. I have uncertainty because I don't know what the state of play is right now, particularly at the Department of Justice, on these issues.
Okay, and Laura, you wanted to add something on remedies?
Yeah, I would like to say that I think I'm agreeing with Sharis that the agency should be open to developing creative remedies that are tailored to the facts and the potential harm involved in the transaction. I understand why there's a preference for structural remedies over a behavioral fix, but as Sharis said, there are lots of areas where behavioral fix may be an appropriate resolution, and that may be a better result than allowing either a flawed merger to proceed that may result in harm, or blocking a merger that would have largely been positive. So just as the agencies are flexible in adjusting their analysis to the factual circumstances, I think they should be flexible with respect to mergers and remedies of mergers as well, in the horizontal and in the vertical context. And of course, there are some instances of where a remedy may not be possible, and the agencies will have to decide whether they want to challenge the transaction or not. But the remaining creative in terms of finding options on remedies, I think, is an important flexibility that, as Sharis has pointed out, we're not seeing in the statements from DOJ at the moment.
So let me go to John. John, you actually, in your speech on verticals, talked about this issue. And one of the things that I previously noted is what you said was not actually that different from a lot of what Macon has said. And in part, the point that you made that divestiture is often the right remedy, even in a vertical merger. Do you want to elaborate on that?
If I could, just a couple of points. I think it is useful to note that across two administrations and in both agencies, including your speech on vertical, Bruce, we've had skepticism expressed about behavioral remedies. Now, different levels of skepticism perhaps, but a skeptical view. So what can one derive from that? I think there's a couple of things. One is, clearly, I don't think anybody disagrees with this, if it's possible to have divestitures, that's a better outcome. Okay, because the economic incentives then begin to work by themselves. It doesn't require an agency oversight. Secondly, behavioral conditions can be difficult to implement. One can read some consent decrees that are in effect now, and they look very difficult to parse, very difficult, therefore, to enforce. So to have a behavioral condition, one really wants to make sure that it is monitorable with the resources available in an agency, and that outcomes are measurable, and that someone would be able to prove pretty easily and quickly whether there's a violation, right? If you don't get that, then you don't know, you don't have confidence that a behavioral condition will work. That said, of course, nobody has closed the door, not including Macon, to any behavioral remedies, and I think there's three kinds that we ought to be thinking about more research on, right? One is information firewalls of the kind that the FTC has used in, for example, the Broadcom merger. Important to understand, are they monitorable, measurable, and work? Because they do have a great deal of an immediate appeal. Secondly, as Shara says, arbitration. How does arbitration work? And by the way, when we ask about arbitration, we ought to ask not just whether the merged firm gets prices that are too high, but whether it gets prices that are too low, right? We're trying to reproduce a competitive market, so we want to know how arbitration will work. And thirdly, if I could just say for a minute, I think non-discrimination requirements require a lot of study, right? By my count, the two agencies together since 1994 have imposed non-discrimination remedies in 5 telecommunications mergers, and that includes 2 from the 90s from the Federal Trade Commission. Non-discrimination requirements have a lot of appeal. They look external. They're not about internal product development. They're asking for a certain kind of parity that one thinks one can establish by virtue of marketplace data. On the other hand, and by the way, they find voice in congressional statutes of the kind Gene has talked about, and in FCC conditions, for example, in AT&T DirecTV. On the other hand, what does it mean to be discrimination is something that the FCC has looked at since 1934. It's not always an incredibly simple question. But I think to the points that have just been made by Laura and Sheriff, if we drill down on this question of whether non-discrimination can be effectively enforced, perhaps through arbitration, perhaps through otherwise, I think we would know a lot more about a critical ingredient that we've tended to use over and over again in behavioral remedies.
Those are good points. I'm going to go quickly to Paul and then Gene on this, and then because we're under 10 minutes, I have a question to all the panelists that I'm going to go to Steve first on, and then see what everybody else's views on it are. And then we'll see where we are in terms of how much more we can get in. But Paul, you wanted to say something?
Yeah, no, just very quickly. I mean, I think behavioral remedies, in the way that they've been used, in particular with respect to non-discrimination and provisions and information firewalls, that they actually do reflect I think, an appropriate level of skepticism or uncertainty about the potential anticompetitive effects of the transactions in which those behavioral remedies have been used, and they also reflect, I think, a recognition, an appropriate recognition of the inherent efficiencies in those transactions, or at least what people understand to be the efficiencies associated with those transactions. So I think we should probably be, in the context of non-horizontal mergers, a little bit less skeptical about about whether behavioral remedies can be appropriate. I mean, I think and I've said this before, that it's a little ironic that the justification for challenging, for filing the first preliminary injunction action against a non-horizontal merger in over 40 years was the regulatory humility. I mean, I think a little bit more humility might have led actually to using a behavioral remedy of the type that was used in Comcast NBCU. So Gene, you wanted to comment on this?
Yeah, I mean, I can't disagree with much of the framing that John put out there, but the problem with it is it's a little too theoretical for what is happening in actual enforcement. And that is the easy case to be worried about is where a behavioral remedy is offered and it's the easy way out for enforcers, and we ought to avoid those in all circumstances. That's just shouldn't be on the table. The harder case, which is what I think we need to be focusing on, is where you find there is a competitive harm. You could litigate, but your judgment of litigation risk is rather high. And I think that's often the case. And so you have a 50% chance of remedying the full harm, and you have an alternative. And then you do the assessment that I think Sheriff was talking about, is how much of the harm would it really take care of? Is it as ministrable as John talks about? And you might be getting at 60 or 70% of a problem, but you might have 100% likelihood of achieving it. That's an important balance to keep on the table, I think, and I wouldn't underestimate it. The downside is in the kind of markets that Steve was most focused on, oligopolistic markets, where we have substantial concerns. There's an equal problem to what Shara said about business uncertainty, and that is the uncertainty of the public that you're really getting at the core problem. The Comcast NBCU decree just expired. I would assert that that market is every bit as concentrated as it was when we started that case now, and the concerns are equally great. And so while there are aspects of the decree I think that worked well, there are a lot that didn't do everything we would have liked them to do. We now have a problem of the expiration. So it works on both sides here, that it's most uncertainty for businesses, but it's uncertainty for the public as to whether you're really getting at the core problem. Again, some of these may take what John was referring to, which is a sector-specific regulator that has the task of figuring out some of the longer-term structural issues in a sector. And it would be nice if you could have parallel action between antitrust enforcement and sector-specific regulation that actually protects competition and maybe even enhances competition. I'll just flag that our biggest issue right now is that for the tech sector, we don't have that kind of a regulator, and I think that's where we're going to struggle the most on vertical questions.
All right, so Steve, I think, was collecting some thoughts on some really complex remedies, but in the interest of time, since we're under 5 minutes, I'm going to go to this question from the audience, and then we may come back to that. But also, I wanted to say right now, just this panel ends in 5 minutes. After that is the lunch break. Before we go to the consumer welfare panels, there's a cafeteria 2 floors up in this building, which has coffee and protein bars, and may have other things, but I wouldn't know. Oh, and donuts. It also has donuts. May have other things, but that's right behind the chapel. There's an adjoining cafeteria in the next building over, and there are a lot of restaurants for whose quality I cannot vouch in the neighborhood. So after this, you're free for lunch. So let me pose this question to all the panelists. And parenthetically, if there's anybody here from Capitol Hill, I want to state that the predicate or the assumption in this question is something that could be thought about. So for those of you from Capitol Hill, with that in mind, I will now ask the question. Agency resources are both constrained and fixed. That's
that was the part of the question you wanted them to pay attention to?
Just saying, you know.
Okay. Check.
Should the agencies devote more resources to investigating or challenging vertical mergers, recognizing that those resources must come from somewhere? You know, again, leaving aside the assumption in that question and whether it's necessarily always valid.
I'll
Steve,
start. I'll say no. Okay.
Paul's got his point out. Go ahead,
Thanks.
Steve.
I'm going to go with the predicate. I think Bruce should do fewer retrospectives publishable in Econometrica and do more investigation of vertical mergers. Bruce Cobian.
Right. I figured that was probably the Bruce you were talking about. And just anyone else have thoughts on resource allocation questions? But I mean, I posed the question in a semi-facetious way, but it's a very serious question because we have to figure out what are we going to do with the resources we have at any given moment.
First of all, I completely endorse your view that agencies need more resources. But I'd say it this way.
For the record, I didn't actually say that.
No, I'm sorry. I apologize for misattributing that to you. Look, this is why we need guidelines. What we really care about is harm to competition, harm to consumers. So what we really want to do is allocate resources, investigatory and litigation resources, to the places of the greater harm. My only view here is that one cannot neatly dissect harm into whether it's horizontal or vertical, because to the point Steve's made, all harm is horizontal. And other vertical mergers, if they are harmful, yield horizontal harm. So I think we need guidelines to help at the beginning of investigations, when memos are being written, theories of harm are being discussed, to try to identify those places where harm from a vertical merger could be sufficient, could be grave enough to justify the use of resources, as one does with horizontal mergers.
Can I add to that? So I want to pick up on something. I just don't want us to overlook litigation risk, right? I do think, and again, I can tell you there were meetings when I was at the Department of Justice where we thought about litigation risk, and we thought about, we don't care if we win or lose. This is worth going out and making a statement about. So that happens too. But I think this calculus that Gene was talking about losing, and then what is the case law going to be that emerges? I have to say, a wise person told me when I got to the Department of Justice that you need to think about every action that you take, you know, and the benefit to consumers or not, and the advancement of antitrust law and thinking. And so the risk that right now we face, you know, if you're an enforcer, the enforcement agencies face a risk that this Court of Appeals is going to come down with a paradigm on vertical mergers that is going to mean there is no more enforcement of vertical mergers. That was the risk the Department of Justice took. I'm sure they took it knowingly because the kind of discussions that we had went on. But I do think that we think about allocation of resources in the cases you bring and you don't bring. I do think that you actually, the litigation risk component of it and the advancement of antitrust law and where the courts are today and thinking about these issues, we saw it in Judge Leon's opinion in AT&T Time Warner. That was a risk that the Justice Department decided was worth taking. We'll see if it pays off or not. We'll see what the Court of Appeals does.
So if I
We
could
have
just
25 seconds.
Now,
so
just
go
jump
ahead.
on that. I think Sheriff is absolutely right, but I will say that in terms of resource allocation, if you have cases to bring that are vertical cases, this is the time to do them, because having ripped the Band-Aid off with AT&T, Time Warner, I think we need to know better what the enforcement practice will be going forward and have that not be the sole action. If there are not cases, I think vertical guidelines are the next thing we should look at.
So,
Well, please,
I would just
go ahead,
close
Laura.
out to say
Laura
that
will get the last word.
In the context of this panel, whether we end up with new vertical merger guidelines or a good report that comes out from this session, we'll have hopefully a bit more guidance for staff, the companies, the bar, and the courts.
Great. Well, please join me in thanking a really excellent panel. And it's lunchtime.